The MK party has dealt another blow to the ANC, succeeding in its trademark dispute with the party. This means that the MK party, if nothing changes, will be able to use its name and logo in this election. In this episode, we'll help you make sense of the political and legal significance of this case for the 2024 election and beyond. Let's get started. Spread the fire. Welcome back to SMWX, your home for election content in this election cycle. If you're new around here, my name's Dr. Sizwe Mpofu-Walsh, and on this channel, we explore South African politics through interviews and analysis. Before we get started, help us get to 100,000 subscribers before this election. That's the goal. We're just about to cross 90K subs, so thank you to all of you who have already subscribed. Okay, let's get into this seismic judgment for this election. The MK party can use the name and logo that it intends to use for this election. In this video, I want to first give you the context in the background and separate this case from some of the other MK party, ANC, and IEC cases. Once we've done that, I'll go into the judgment itself. It's very fresh, but I've had a look at the judgment and I'll break down exactly what the court found and try to tell you some of the court's reasons. And then finally, we'll look at the political significance of this because, of course, law and politics are deeply intertwined in this election. And what really matters for May 29th is what does this mean for the election and its outcome? So let's get into the context of this. Now, I did a previous video where I broke down the different MK cases. So if you really want to know in depth what the different cases have been, have a look at that video. But in a nutshell, there are 3 different election cases involving the MK party that have been happening. The first one was about whether the MK party could be registered as a political party. The ANC took them to court, said that their registration was irregular, and the court ruled against the ANC, so the MK remained a registered party. The second dispute was about whether former President Zuma could be a candidate on the list of the MK to go to parliament. And that the MK won again. The court said he could be a candidate on the list, but the IEC is appealing that to the Con Court, and we await the outcome. And then the third case, which is this case that we got the ruling for today, was about whether the trademarks of that the ANC purports to hold in the name Dr Sizwe and in various logos were being wrongfully used by the MK to propel its political fortunes, the MK party that is. So basically, could MK party use the name MK? And could it use the logo which has the that figure holding a spear, which is well known from liberation history? And today, the court ruled in that third case, and it said basically, yes, the MK party can call itself Dr Sizwe party, and it can use its logo. So the ANC was wrong to say that in this dispute, the MK party wasn't allowed to use those names and logos. So that's a breakdown of the different cases, and this case, and the importance of this case for the election. What does it mean when you get your ballot in the election and you're standing in that booth because you're a great citizen and you're already registered to vote? You will be able to look at the different options, and MK party with the logo and the name will be there on the ballot. The ANC didn't succeed in removing that from the ballot or forcing the MK party to change its name to something else. So that's essentially the context. Let's now get into what the judgment of this court from Judge Chetty really said and why it ruled against the ANC and for the MK in this trademark dispute. Right, so as I mentioned, this judgment is quite fresh, but on the day of the judgment, let me try and break it down for you so that you can try to understand this case a little better. You can really think of this judgment as broken down into 2 parts, what are called the preliminary issues in most court cases, and then what are called the merits. What that means is just the preliminary issues are not about the actual substantive issues in dispute. They're about things like whether the court has the power to hear the matter, or whether the matter is actually urgent, or whether the parties in the matter have the capacity to bring the issue to the court. So those are all preliminary issues, in other words, issues that come before considering the substance. And then there's the merits, and the merits are about the substantive issues. Does this trademark actually confuse voters? Does the ANC have rights to this trademark? Is the MK infringing those rights, etc.? So when it comes to the preliminary issues, these really became quite central in the judgment. And there were two main issues where the court found for the MK party. The first issue was on the question of whether this is urgent. So remember, the ANC brought this matter urgently to this court and said, hey, this really needs to happen now. It needs to happen very fast because this matter is one of serious urgency. And the court said, basically no, because the MK party registered in June. The ANC only tried to retrospectively register this trademark, as I understand it, after that in September. And then they came to the court once they had taken the first steps to register the trademark. So the court basically said, hold on a second, what happened between June and September? And why did you take so long to challenge the MK party? You should have challenged it if it was really urgent as soon as they registered that and the IEC approved that registration. So in a nutshell, as I understand it, the question of urgency came down to the fact that the ANC didn't act fast enough and only brought this belatedly after they realized the political significance of the MK party. But they didn't do it as soon as they could have become aware of the registration of this party. So that was that issue. And the court said, look, you came here urgently, but in fact, many of the delays were your fault, in a nutshell. But then there was a second, probably much more important preliminary question of jurisdiction. And jurisdiction just means, is this the right court to hear this issue? Or does the court have the power to make a decision on this issue? And we have two kind of competing sets of laws. There's trademark law, which is the law that deals with really trademark and commerce. And, you know, if you have a trademark in a beverage company, I won't give any free advertising away. And then someone just copies the name of that beverage company, whatever your favorite beverage is, and they just change one letter, right? In the market, your rights would be infringed because you've built up a whole lot of capital effectively in that name, and now this person is going to trade kind of using your name, right? So there's that law, which is trademark law, which is about intellectual property rights in a way. And then there's a different set of laws, which is electoral law. And that is the set of laws which govern how the election should unfold, what would constitute a free and a fair election, and are political parties competing in fair ways for voters. And you'll notice that although they're quite similar, those are two different kinds of laws. One is more tailored towards market dynamics and economic dynamics, and the other is more tailored towards electoral competition. And what really happened in this case is that the court said, look, this is more of an electoral dispute than a market dispute. However, the ANC came presenting a market-related case, whereas this should really have been presented as an electoral competition case. And in many ways, the ANC had already conceded in some of its papers that this really was about electoral competition. It was about the confusion of voters, not selling of T-shirts or goods or services so much as electoral victory. So the court effectively said, no, we're not the right court really to hear this. The court that should have heard this would have been the electoral court, because there's a whole court, especially during election time, which is dedicated to hearing electoral disputes. The ANC didn't go there. They went to this high court to say, no, this is a case about property rights. And the court said, look, there's a judgment called Kham from the Constitutional Court, which says basically the electoral court and also the Electoral Act says this has very wide powers to hear a multitude of different disputes. And this case really falls within those wide powers, and it would be better to have been brought at the electoral court because it's fundamentally an electoral dispute about voter competition, not market dynamics. So the court said, basically, we weren't the right place to hear this. Now, having dismissed urgency and jurisdiction, the court could have stopped there. But what it said is that if this matter goes on appeal, it wants to also give reasons on the merits, and it found on the merits for the MK party as well. So now let's go into the merits of the case as we continue on the legal understanding of this case. So ANC came and said, look, here's the Trademark Act. The Trademark Act gives us certain rights, and the MK party has infringed these rights. So under Section 34(1)(a) of the Trademark Act, you can't use effectively, to cut a long story short, you can't use a registered trademark which causes confusion in the marketplace and in an unauthorized way. So the ANC said, hey, MK party is doing this. And basically, again, the court said, this is electoral politics, not so much market dynamics. And so in terms of the statutory requirements in the Trademark Act, the MK hasn't fallen directly foul of that. Now, the court also said that it's not clear that voters or even people in the market would be deceived because there is a sufficient difference between the ANC name and logo and the Mkhonto we Sizwe name and logo, and especially the logos, even though there are some similarities conceded by the court. A casual observer or a relatively interested market observer, or whatever the relevant test is in the judgment of these questions, would be able to distinguish the two marks. And in the judgment, they actually put the two up, and you can actually see them. And it is fairly clear that a rational individual would be able to distinguish these two. So then the second argument is about section 34(1)(c), I believe. And this is that even if there isn't confusion caused, then the owner of the trademark accuses the other person of passing off. And effectively what this means is that even though there isn't confusion, there's still some kind of disadvantage created in the marketplace by passing off your logo or trademark as that of the rights holder. And again, the court said no in this case because it would not be to the benefit of MK party to confuse voters that it's the ANC, because the whole point of elections is not to give your votes to other parties. So the court said, it just seems strange that the MK would try to look like the ANC, in which case it would be shooting itself in the foot, because it would then possibly give votes back to the ANC because people would be confused. There's no reason why in the confusion people would only vote for MK. They might mistake the MK for the ANC, and then that would help the ANC. So on the merits of both the statutory provisions and the common law right, the passing off, which is to some extent, I think, recognized in 34(1)(c). Again, I'm not a trademark lawyer expert, but I'm just trying to interpret the judgment. Again, this was found against the ANC. So that's a brief breakdown of why the ANC didn't win this case. They lost on preliminary issues, and then they lost on the merits of the case as well. And ultimately, the court said this is not urgent, this is not the right court. And thirdly, even if it was the right court, the merits of this case don't fall on the side of the ANC ledger. So having looked at the legal analysis, let's now break down the political analysis. Okay, so let's come to the politics of this case. And really, I think this is another major political win for the MK party. They are fresh from two recent court victories, which just make it look like various forces are lining up to prevent them from coming onto the ballot. And what that also looks like is that particularly its political rivals are doing everything they can to prevent the MK party from contesting, because it looks like they are worried about what would happen if the MK party contests. You wouldn't invest this number of resources and this amount of time if you thought that this was a trivial political moment. But clearly, the ANC particularly thinks that preventing the MK party from contesting is in its political interests. And unfortunately, it has been defeated now twice. So it lost the registration case. It's now losing this trademark case. The other case was more in terms of the IEC. So that case about the Zuma contesting for the list is slightly different, but it also benefits the ANC as well in some ways. So I think from the perspective of whether we look at this if we just look at this as a zero-sum game, MK versus ANC, the ANC has been roundly and squarely defeated. They didn't want MK to be registered, and they didn't want the MK to be able to use its logo and its trademark. The MK is registered, and it can use its logo and trademark. Now, I think there would have been a bit of a dent in the MK vote if they had to use a different trademark. I don't think it would have been significant, but maybe marginal, where people knew about Mkhonto we Sizwe, and then they would have been forced to change their name, and then they got to the ballot and they weren't sure whether this party was in fact the old party. Now, all of this capital that has been built up in Mkhonto we Sizwe party in this election can now be transferred onto the ballot. And so it will be clear to people who they are voting for. And on the ballot, as we know, it's going to say Mkhonto we Sizwe party or MK party. It's going to have their logo, and then it will have the face of former President Jacob Zuma. So This means that MK will probably do the maximum damage that it can in this election. And if you watch some of my other videos, I think MK is a potential game changer and will drive the ANC below 50%, definitely, possibly even to the low 40s if the polls are to be believed. But look at my analysis of the polls on that. Of course, the more recent polls will be more likely to indicate the outcome, so we await those. But I think this means that the ANC is in big political trouble in this election as far as trying to secure an outright majority and potentially even a sizable minority where it can get a few small parties together. For the MK party, what this means is just more momentum. I've continued to say that the MK party is a new party. It's hard to form a new party. There are inevitably internal divisions. We've seen that with Nkosi Kanyile, who seems to have been removed from his position. The center of power can always be a difficult dispute. Instead of having to deal with all those issues, the MK party has just had been united by all these outside forces trying to stop it from being on the ballot. And ultimately now, once again, more unity in the party, more good vibes in the party, more momentum towards 2024. So I again think this is going to be good politically for the MK party. Once again, just to say, this doesn't mean I'm an MK party supporter. I'm a political analyst. I'm not a member of any political party. But I try to analyze things as they are. And there are a lot of analysts who kind of say, yeah, it might be half of one and, half a dozen of one and six of the other. No, analysis is about actually coming out with a viewpoint. And my viewpoint is this will be very good for the MK party. They, of course, have the direct appeal to the Concourt. We'll see if the court hears that, but whichever way that goes, I think MK Party will be able to exploit it, and I think that they're on solid legal ground on that as well. Before these judgments, I've continued to say I think the MK Party is on solid legal ground, and the judgments have confirmed that. Let's see what happens in the Concourt, but I think if you listen to those arguments very carefully and you look at the Constitution carefully, the MK has some very strong arguments to make, but let's see what the IEC also tries to conjure in that appeal. So taking a step back, what happened in today's judgment is that in one of the three MK cases, the MK party was allowed to use its logo and trademark. This means it can be on the ballot as is, and it doesn't have to change anything. This is good news for the MK party, bad news for the ANC, and that tells us that May the 29th is set to be an election for the ages. I think it's going to be a historic and a momentous election, of course, not just nationally, but in places like KZN, Mpumalanga, Gauteng. This will also reverberate. Like, share, comment down below. Like I said, we're trying to get to 100,000 subscribers, so help us get there before the election so we can celebrate on election day as well. And let me know, what you think in the comments. Like I say, I don't take my word as gospel. I try to understand these issues and give you an understanding. If you agree, let me know why you agree. If you disagree, let me know why you disagree. And let's continue to improve the public debate around these matters in South Africa. Spread the fire, like, share, subscribe. Aye.